Case number 110048, State of Kansas v. Saylor.
Good morning. I'm Rick Kittle. I represent the appellant, Mr. Saylor, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
The court will recall that in this case, Mr. Saylor was found guilty of a offender registration violation. Briefly stated, this case has its origin almost a decade ago when Mr. Saylor was found guilty of indecent solicitation of a child, an offense which requires registration. He registered successfully for years. In late 2011 and early 2012, he finds himself in some dire straits in personal life. He was having trouble finding employment. He was having trouble finding housing and paying for it. He and his wife both had health problems. And according to him, it was because of these distractions, these problems, stressors in his personal life that he failed to register in February of 2012 when he was required to. The month before, in January of 2012, he went to the Kingman County authorities to fill out an information card, and at that time indicated that he would have a change of address. According to the state's evidence, he was told at that time that the next time he would have to register would be the following month, and he failed to do so. He was arrested in March of 2012 and ultimately convicted of the crime of the registration offense. Now, all of this happened prior to State versus Dunn. The appeal that was filed in the Court of Appeals was based solely upon law that existed prior to State versus Dunn, and the claim was that the crime of offender registration violation had certain elements and that the charging document did not contain an essential element of the crime, and therefore it was defective, and the issue raised was jurisdictional. And this court recently directed the parties to file supplemental briefing regarding whether or how Dunn would apply to this situation. And try as I might, I cannot find anything that would indicate that Dunn should not apply, or there's nothing in Dunn that I find, there's nothing in the peculiarities of this case, the instant case, that would indicate that Dunn would not have application. So if that's the sole question that the court wants answered, then I guess I would have to concede that there's not a jurisdictional problem any longer after Dunn. But this case was initiated under the posture of pre-Dunn law. My understanding of the Dunn decision, and it was my case, is that this court is saying as long as the charging document alleges facts which, if proved beyond a reasonable doubt, would constitute the crime charged, then there is no problem jurisdictionally. Because Dunn says jurisdiction, I guess what I was trying to accomplish in the Dunn case was to say, look, State versus Hall from 1992 was wrongly decided. It's bad law. It should be rejected. And this court did reject it, but it also rejected decades of law that existed prior to Hall. So after Dunn, jurisdiction is something conferred by constitutional law, but importantly, and I don't want to overstep my bounds here because I know what the case was at the Court of Appeals level. It was about jurisdiction, and that's what Dunn is about. But Dunn, I don't think, says if there's errors in the charging document, that's no longer problematic. Problems can still be presented if there are defects in the charging document, and I think those are present in this case. If you look at and one thing I've tried to do here is,
let's just walk down that road a second. So Dunn says no jurisdictional problem, but there still might be other problems. Basically, if I read Dunn right, then we're looking at prejudice to the defendant and fairness. And how can we have that in this case when charging documents said you're supposed to register, you're required to register, you didn't register. The defendant stipulated that he was required to register and didn't, and tried to defend on the basis that he had problems in his life that excuse to register. That's where we're at. So how do we look at prejudice based on what's in the charging document?
Okay, I guess
The
there are.
defects that you think are in the chart, because
There
I
are-
don't see any, I don't see any prejudice with what you were trying to do at trial.
I guess there are two arguments I want to make, and I'll deal with the prejudice, and the other also is a statutory argument I want to make. One thing I did in the initial brief and also in the petition for review is set forth the PIC instruction on the crime of offender registration. And one thing I've noticed, and I heard it in an earlier argument today, there are all these terms that are thrown around about what goes into a charging document. Sometimes they're referred to as elements. Sometimes they're referred to as facts. That's what Dunn says. The statute says facts have to be alleged. They're called allegations. In PIC instructions, they're called claims the state has to prove. To me, they're all kind of the same thing. So if you look at the PIC instruction for offender registration, it basically enumerates, as do all PIC instructions, what the state has to prove, which I believe gives some credence to the argument that elements is still a good way to refer to what the state has to show. There are 4 enumerated elements in the PIC instruction. And it's the 4th element in the PIC instruction that is an issue here. Because not only does the state have to prove that the offender had a duty to register, the statutory law requires, and the instruction would indicate also, that the state also has to prove the reason why the offender had a duty to register within a particular county or jurisdiction. And if you look at the PIC instruction, element 4, there are multiple versions of element 4 that the state can rely on. In other words, the state may have to prove that he had a duty to register in Kingman County because he lived there, or because he was employed there, or because he went to school there, or because he just happened to be there. He might be homeless, doesn't have a residence. Or it may be required that the state prove that he had to register in Kingman County because that's where he was convicted. Those are all separate versions of element number 4. So if element 4 is missing from the charging document, the defendant really doesn't know which version of element 4 the state is relying upon, and it really doesn't understand that that is something that the state has to prove. Now, the Court of Appeals said, well, in this case, the state must have been relying upon Mr. Saylor's residence, and that's why he had to register in Kingman County. But what the Court of Appeals referred to is just some listing of a residential address in the charging document within the 4 corners of the complaint. That language was not included in the actual count charging the crime. To me, that indicates that the state didn't even understand that that was an allegation, that that was a fact that they had to prove to constitute the crime. So if the state doesn't understand that that's an allegation that's necessary for the crime, how is Mr. Saylor supposed to understand that? So I think that's where the prejudice lies. He would not have been fully informed of what he was being charged with, which version of the crime he was being charged with, exactly what the state had to prove to show that he had an obligation to register within Kingman County.
And I don't understand that. I don't understand how a defendant is scratching their head when it's not in dispute that he was required to register, regardless of the reason there, and he stipulated to the information, to the facts that would say why he's required. So I don't understand why there's prejudice, why there's some doubt about this element. He doesn't contest that he didn't have a duty to register. His argument is, I was busy doing something else.
That's correct. But the specific nature of the issue raised below is that there was a defect in the charging document. And to that end, to that purpose, I think there has to be, and even after done, there has to be adequate facts alleged in the charging document, which if proved would constitute the crime charged. And I don't think that has happened in this case.
How is he prejudiced by that? I'm still getting back to how does this negatively impact the defendant under these facts?
I guess, and what I'm arguing is he should be entitled, constitutional law, he should know the nature of the charges against him. He doesn't specifically know the nature of the charges when there are multiple versions of this crime, and the state doesn't include the information within the charging document to inform him which of those multiple versions of the crime he is actually having to defend against. And I realized that his defense was not, I didn't understand what I was being charged with. It was, I've got all these other things going on, these distractions that caused me to fail to register. But the fact remains, even after done, there are certain requirements that a complaint has to contain certain information. And although that problem is not jurisdictional consequences, it still is problematic. And I think Dunn indicates that there's still a problem of notice, that the defendant has to be put on notice as to exactly what he's being charged with so he can adequately prepare a defense.
Let's go at this a different way. After done, you can have a defect in the complaint that is harmless, since it's not jurisdictional. Would you agree with that?
I would hesitate to bring in harmless error analysis into this. I think Dunn certainly says that defects in the time out of mind. Since I started practicing law, my understanding of the law was the complaint is the jurisdictional instrument for the trial process. Dunn sets that on its ear. It says it doesn't make any difference if there's a defect in the complaint. You can't raise that as a jurisdictional problem any longer because jurisdiction is conferred by constitutional law, not by this instrument. But Dunn also indicates that there are still problems if the complaint is not properly drafted. And I think one of those is...
It also says that those problems are subject to harmless error review, doesn't it? I think it comes right out and says
Okay,
that.
well, if that's the case, then...
Okay, and that's all
If-
Justice Johnson's trying to move you to.
If that is the case.
Yeah, let's assume for purpose.
Assuming without you conceding that harmless applies, why doesn't a concession that he had to register in Kingman County render any kind of confusion as to whether that was his residence, place of employment, or where he went to school, because he's conceded, and it renders harmless any perceived notice problem because he says, hey, I agree. I had to register here.
I guess my answer would be because that's not all that the statute requires. It's not enough for him to concede that he had a duty to register in Kingman County. It has to be stated in the charging document the reason why he had a duty to register in Kingman County.
If everyone agrees he had a duty, why does the reason matter?
Well, again, the issue presented here is one of what's in the charging document. Now, whether he was prejudiced or not, I've made my argument about why he would have been prejudiced here. But, you know, this is a situation where, yeah, he made his concession.
I could see the argument having more force, perhaps, if a hypothetical defendant were to have defended on reason X, and then the state came back and said, oh, no, we meant reason Y. And now you've got a notice due process kind of problem there because the complaint doesn't sufficiently inform the defendant of the allegations against him.
Right.
But as Justice Biles said, when you have a defendant who just says, I was required to register in Kingman County, I don't contest that.
Right. Well, I don't know that there's any more I can say about that. I did mention that I had two arguments here, and I see that I've run out of time. I would ask the court for some indulgence and just to give me a minute to present the other argument that I wanted to present on statutory law.
The stopwatch is ticking.
Very well.
No. You have 60 seconds if you want to take that
Thank
time.
you. KSA 215109B states, quote, "The defendant may be convicted of either the crime charged or a lesser included crime, but not both." To me, that is a statement that can only make sense if that is read to be a crime that is adequately charged. So, if the defendant may only stand convicted under the statutory law of a crime that's adequately charged, if the crime in this case was not adequately charged, I believe conviction here is prohibited under KSA 215109. To me, that statute is much like the conspiracy statute. Conspiracy statute is unlike, to me, any other statute that defines a criminal act because it has a provision in its language that says no person may be convicted of conspiracy unless an overt act is alleged and proved. This says, that provides the reasons or the circumstances under which a person may be convicted of conspiracy. This statute has a much more general application. It says a person may only stand convicted if a crime is charged. And in this case, our argument is there was no crime charged because there was an element missing from the charging document.
So you're saying that the reason for the duty to register is akin to the overt act in conspiracy? Is that your argument?
I guess you could view it that way. I'm just saying that conspiracy has within its provisions a statement of the conditions under which a person may stand convicted of that crime. This statute, 5109, has the same effect. It says you can be convicted if there is a crime charged. My interpretation of that is if there's not a crime charged, and we're arguing there was not a crime charged in this case because an essential element was omitted, then the defendant may not stand convicted.
And his stipulation would have no bearing on your analysis, is that correct?
Right, because that's the way that this conspiracy statute has been interpreted. It doesn't make any difference for conspiracy. Even if they prove an overt act, if it's not alleged, the defendant may not stand convicted because that's what the statute requires. And after done, what is required is facts be alleged in order to constitute a crime. If those facts aren't there, you have no crime, and the conviction may not stand under 215109. And I think I took more than a minute.
Any more questions? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. We first have an issue. Dunn says you can't reach the issue of a charging document deficiency if there was no exception raised or argued, and there was none. I pointed that out in my supplemental brief, and then no reply brief was filed arguing any kind of exception that would allow this court to even reach this issue. But even if this court does reach this issue, I think the discussion today clearly proves there was no prejudice here by any kind of alleged deficiency in the complaint. And thus the conviction should be affirmed, and I think the same reason there was no prejudice in the complaint, or any deficiency in the complaint, is the same reason the jury instruction error also fails. He stipulated that he was required to register. He knew he was required to register, and we proved he resided in Kingman County. If there are no further questions, the state would respectfully request that the district court be affirmed in this case.
Is the reason registration is required an element of the crime?
I don't think so.
And if it's not, why is it listed in PIC as a separate
well, first, the way...
claim of proof?
Right, and at the time this jury trial happened, it wasn't listed in PIC. PIC then was subsequently amended to list it, and PIC is not law. So the fact
Well, is that PIC wrong? Is it wrong to list the reasons as something that must be proved by the state?
I don't know. I mean, I don't think it does any damage if we have to pick that you were either employed...
Well,
here
it
or
might matter
somewhere.
if it's an
Yeah.
element of the crime, right? That's why I
Right.
first asked if you thought it was an
I know.
element of the crime.
The element of the crime is that you have a duty to register and that you didn't do it, and whether or not we have to prove specifically what that duty is I don't think we have any case law that answers that.
What do you think the right answer is?
would seem typically if you have a legal duty, you have to prove that legal duty as well. But I don't,
The reason for it?
yeah,
Says
the reason for the duty unless it's stipulated to. But I'm not, I don't know.
I recognize you can't, you're not committing to this.
Right.
But, you started out saying it's not an element, but now it sounds to me like you're maybe talking yourself into thinking it might be an element.
I don't know. I mean, I think that the duty to register, if we listed all three, you had to do one of the three. Is it like an element or alternative means? I'm just not sure. It seems more like an alternative means. I don't think I'm trying
Well,
to
the
think
complaint clearly alleged that he had a duty to register in Kingman County.
correct.
It doesn't allege anything, it doesn't drill down into that. It doesn't say he has a duty to register in Kingman County because XYZ.
No, it points to the statute that would have told him that he would have had to register because he resides.
But there are multiple reasons why an individual might be required to register.
Correct. And if he had to, but he'd only have to register one. If he resided in Kingman County, if he was employed in Kingman County, if he went to school in Kingman County, I don't think we can hit him for 3 separate registration requirements if he doesn't register in Kingman County. So I'm thinking that they're alternative means rather than an actual.
Does a defendant have a right to know the means by which the state is alleging he or she is violating the statute?
I think if the allegation, or sorry, the due process issue that you raised in your question to counsel where he defended on, I didn't have to register because I didn't go to school here, and the state turned around and said, well, that's nice, but we're charging you with living here, I think that would be a due process issue. Yes.
So you can have a due process issue arise even when it's not an element of the crime, if it's just an alternative means of proving the actus reus.
I think if we don't specify and your defense is prejudiced by it, there are, yes. I mean, I know there are Court of Appeals cases where it's a factual thing, like the deadly weapon. I had a case where there was a fight about whether or not the deadly weapon was a pillow or a gun. And the pick just says deadly weapon, so the pick doesn't pick, but then there was a weird jury question, and the issue is whether or not there's some kind of right that if the state can change, because the state proceeded based on the
State can
name.
endanger its prosecution by overpicking, though. I mean, if it alleges something specific and then it ends up proving something different, that
Yeah,
causes you
that-
a problem too.
Right.
So you don't want to overcommit here, I would suggest.
I completely agree. And you're right. We use the language of the statute because that is what the way the complaint statute tells us to do, and because if the more we narrow it down, the more we have problems. Here he was told in the language of the statute that he had to register because of this subsection of the statute that would have told him. And I actually don't know that the due process issue would have been a problem unless the state originally said in the jury instruction or in the complaint, it elected and said, we reside. I'm totally backtracking on my original answer.
So if the element of the crime, if one of the elements that the state has to prove of this crime is a legal obligation to register in a specific county, then this complaint, even if we are able to reach the issue, is not defective.
Correct.
And so that's a bill of particulars issue.
Yes.
Okay.
Now then-
Any further questions? No further presentation?
Thank you.
Thank you, counsel.
No, you're on. Thank you.
Thank you.
Unless the court has further questions,
Any more questions?
I do have a question.
Would you step up here, please? Thank you.
We talked exclusively, I think, about the defective complaint issue when you were up on your original argument. Do you want to say anything different or add to it or differentiate in any way for the jury instruction?
That was an issue, I guess, that was raised in the original brief for the Court of Appeals. Well, the only thing I can say was I wasn't anticipating Dunn coming down the pike 2 years later. I thought that this issue would be the more focused one to go on because it was, I guess, the more established law and one way of thinking about it. So that's what I decided to go with. I don't really have any other response than that.
Okay, thanks.
But it would be difficult to find that the any omission in the jury instruction was prejudicial on a fact that was stipulated by the defendant, wouldn't it?
Yes, yes, I agree.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.